ParkerGPT is just for debt defense, so don't go generalizing in other chat boxes. This is me selling this thing, I get it. But think about what I'm saying. If you wanted to get your car fixed, you wouldn't go to a brain surgeon. So I'm a mechanic, I'm a debt mechanic. If you want to go to a brain surgeon because they're smarter and have more knowledge, you're unlikely to get them to fix this thing properly. They're going to spend all day researching it and give you the incorrect information. You want your car, your debt car fixed? Come to the mechanic. ParkerGPT. And now they've got a whole plate of wrong. They've made things worse for themselves. And now the judge says, I don't get this, I think Parker's right. You have to cause legal chaos. 99 times out of 100, I file a motion to dismiss. It just brings everything to the front and it settles cases. You can't substantially adhere to the statute. You have to either follow it or it's void. Hey, Brian Parker with an interesting one today. I do a lot of case studies where a person is involved in a case, does great, and I say, hey, send me the doc, send me it in Word. And I invite you to do that too. If you want to send me your stuff, I'll do a video of it if it's interesting, or I think it could be educational more than interesting. Hopefully both. But this is one of a case that I am currently involved in. And as you know in my video, do I answer or do I do a motion to dismiss? I, in most cases, say I recommend you do a motion to dismiss and ferret out either that they don't have the docs or the crappy docs that they claim they have. So this is the latter. This is the video on somebody responding to a motion to dismiss where the court said, you know what, Parker, you're right. I'm not going to give you a dismissal, but they've got a certain amount of days to respond to what you're asking. And this particular court I was in front of, I was very surprised it went down like that. And so the court said, I need this, this, and this. That's good too, because what happens is they never had the stuff, but now they've got to do all this stuff, and you can kind of see what they're up to. Let me put it that way, in the information that they produce that they didn't have when this went to court. And now the judge says, I don't get this, I think Parker's right. The judge says Parker's right. That's pretty good. So I'm going to show you what the judge said to do, what they did in response, the debt buyer, and it's just a plate of wrong. But I want you to be educated on the chain of title, the kind of the BS that is done. I'm going to help you identify and not doubt yourself when you see something is wrong, and put it either, if it's the beginning of the case, into your counter affidavit, into your motion response, or even into your motion to dismiss, which again, totally up to you to do what you want to do. But when I get a case now, 99 times out of 100, I file a motion to dismiss. It just brings everything to the front and it settles cases. So you do you. You do the voodoo that you do. But I'm going to show you my voodoo and take it or leave it. So in this case, it's Crown Asset saying my client owes them a debt. Oh, let me just say this. Attach this video at Killdebt.com, Kill 2.0. It's going fantastic. It's a lot of fun. I literally spent the whole morning on it preparing this. Now, before I get accused of using a chat box, it's my chat box. It's ParkerGPT, and it helped me navigate through a very difficult situation. A, I got to present it so you are somewhat interested, and B, this is how I'm going to respond when I respond back to the court about what the garbage that they presented. So I'm literally writing the brief with you in mind, and I hope that's helpful to you. So I'll have the actual motion to dismiss that I filed in Word attached to this video. I'm going to throw in a third-party complaint I filed against Trust and Upstart Network. I'll put that in there in Word. You want to mess around with it, it's a good way. If you want to do a plaintiff case, a federal case, you could use the third party, but the bones of the third party case. I'm going to give you my show notes, obviously, and I'll make sure, I'll throw in something else in there that will be helpful. I was going to do a checklist, but that isn't really appropriate here. So I'll give you 2 motion dismisses. So 2 motion dismisses, a third-party complaint filed against the Trust and Upstart, my show notes. This took a long time today. And also, I'll make sure you've got plenty of stuff on there. Go to Killdebt.com with ParkerGPT. You just feed the documents, and that's what I did the whole morning, of feeding it documents, getting results. using the results, having a question, feed it more documents. So let's take a look at those documents. So in this case, Shazam, the original creditor is Finwise Bank. The bill of sale showed a Delaware Loan Purchase Trust U sold a pool of debts to Crown Asset on September 26, and Exhibit K, where Finwise Bank is transferring something. These Exhibit Ks that are locked into these fintech loans now, they don't say anything. They say the creditor's transferring it, and then they say no transferee, or the person's being assigned the debt. So that's an important thing. Remember that. So the Exhibit K that was signed either September 29th, 2023 or 10 October 2023, significant because the September 26 document says, hey, here you go, Crown Asset, and then they sue my client. But it wasn't until 3 or 4 days later that Finwise, the original creditor, gave it to somebody. So how does Delaware Trust give it to Crown Asset, the eventual plaintiff, if the original creditor has not given it to anybody? So now Crown Asset is suing my client. This is a case about an actual case. So here's the bill of sale, Shazam. So you see there's Upstart Network claiming to be just a servicer on behalf of Delaware Loan Purchase Trust U. That's impossible in certain states, and we're gonna go through, let me get to that and then it'll make sense to you. And they've signed it September 26th, and they say they're giving something to Crown Asset Management. So they've gotta have that to sue you or my client. Here's their Exhibit K, Shazam. It's the transfer, and you can see on 3, on or about with no date, closing date, set forth on Exhibit A, no Exhibit A, transfer or transferred or otherwise conveyed the loan to a party identified Exhibit A, no Exhibit A, known as the purchaser, doesn't exist. So I showed in my answer, or do I file an answer or motion to dismiss video, Shazam, remember that. I gave you, let the facts dictate what decision you make. But 9 times out of 10, you're gonna wanna go and do a motion to dismiss just to bring everything to the table. You file an answer, it's just gonna go on and on and on. They'll eventually file their motion. Now you're on the defense. It's always good to be on the offense. So we did file a motion to dismiss seeking proof that defendant's specific loan, my client, came from the original creditor, Finwise Bank, to Delaware Loan Trust, and somehow made it to Crown Asset Management with a whole bunch of assignments missing. So this is exactly what's in my motion to dismiss that I told the court, Shazam. Finwise Bank to Delaware Loan Trust U, September 26 is missing. Finwise Bank to Upstart Network, who is claiming to be part of the Exhibit K. And then Upstart Inc. to Crown Asset, because Upstart is claiming that they own the debt. So that's not true. They were never assigned anything. And so the court agreed with me. And I'm not going to give you the whole order, but this is what happens. You file a motion to dismiss, you get an order, and the court either says denied, granted, or here's what I need. And that's what she said here. Shazam, while plaintiff argues that plaintiff would be Crown Asset, that the loan transfer agreement identifies Upstart Network as the transferee, they did, but they aren't. Exhibit K states that the Upstart was the servicer of each loan from the origination of the loan. So she had a real problem with that. Despite plaintiff's representation, Exhibit K does not identify Upstart as a transferee. Without identity of the purchasers, the court cannot determine if there's been a break in the assignment. Simply, the court is at a disadvantage and unable to determine if plaintiff had standing without a full record, specifically without Exhibit A to the loan transfer agreement. In case you're wondering why judges say what they say, if there's a side they believe, they will transfer that thing that I said into their order. That's basically what I told the court is the problem here. She wrote, therefore, the court orders that plaintiff shall produce Exhibit A to defendant within 14 days of this order. Upon receipt of Exhibit A, the parties may supplement their motion and respond to the instant motion. Defendant may file a supplement limited to 10 pages, November 20. So that's what I've done with this video today. As I was doing, I said, hey, let's make a great video education-wise to explain things to you. So Crown Asset has filed a supplemental response saying, yep, everything's good, we got it, don't worry about it. So let's take a look first. Now, the whole thing in these kind of cases, whether you mention it or not, usually when you're deep in motions, this is going to come out. Your state has a statute of frauds, either a statute or some case law or law that requires and states how an assignment, how a writing is determined. Here's a video I did on statute of frauds, Shazam. That'll break it down for you depending on the state you're in. But in Michigan, everything in writing, in collection and assignments flows through the statute of frauds. So this is a Michigan example, but your state will have their way that a case or a collection assignment is legal. And if it isn't legal, as this statute, and maybe yours does, it's not kind of legal or voidable, it's void. You don't follow the rules, it's void. That means gone. So here's what a valid assignment is under statute of frauds in Michigan. But statute, by the way, look at that video I sent you. Let's put it up again. Statute of frauds. And that's just explaining what a statute of frauds is. It's basically certain things have to be in writing, have to be signed by certain parties, and everything must be inside, in this case, an assignment. So in Michigan, 566 let's put it up there, Shazam, 566.3132F requires that an assignment of things in action must be in writing and signed with an authorized signature. A lot of times I get the other side, LVMV funding does this a lot. They'll say, hey look, we got a signature, but they leave out, and they quote the statute, they literally leave out the word authorized because there's some question as to whether the person who signed it has any proof. There's a case in Michigan that says you got to show the authorization that allows them to sign that. So that'll be part of this case. There must be an authorized signature by the party to be charged. I'll explain that quickly, but it's unambiguous. It's the requirements of valid assignments. If you can't substantially adhere to the statute, you have to either follow it or it's void. So the 566.132 says things in action must be signed by the party to be charged. So let me just give you quickly the statute, boring. Shazam, 566.132, agreements, contracts, promises, and it says right there, in the following cases, an agreement, contract, or promise is void unless that agreement, and in bold, is in writing and signed with an authorized signature by the party to be charged. And then an F, an assignment of things in action, whether intended as transfers to sale, security, or otherwise. So when something is a shall, it is mandatory. This is a shall situation. It has to be in writing and signed with an authorized signature, all right? So a definition of a party to be charged, Shazam, if someone later sues to enforce the assignment, the assigner, that's the person that's assigning, has to prove the assignment is valid. The assigner is the one being charged or held responsible for what is assigned. So briefly, the case law in Michigan is the best case is Weston v. Dowdy. To constitute a valid assignment, there must be a perfected transaction between the parties intended to vest in the assignee a present right in the thing assigned. You can't go, we're going to assign, and you'll see this in every assignment you look at. Effective date, 12 days down the road. Effective date, 6 days earlier. It has to be a present right to assign the thing or it is void. Let me just show you. Present right means the assignee had the right to transfer right now, not at some future time or date. And then the thing assigned means the debt itself. In other words, at the moment a assignor signed or should have signed the assignment, the assignor must have owned the right to collect the debt it is assigning. So they gave me a 2-page supplement. I'll just put it up there. Shazam, Shazam. The reason I'm putting up there is I'm going to show you what you do, I hope, if you want to follow my instructions. And I always talk about breaking down the other side's document. So they filed a document and exhibits of 7 paragraphs. So what you do is, don't let it be a blur. Ugh. What's the expression? Inch by inch, anything's a cinch. So take the first paragraph that means anything. So that's what I did. Paragraph 3, Exhibit K further reflects that on or about the respective closing date, Exhibit A, transfer or conveyed something to purchaser. So this is the Exhibit A, Shazam, and again, I've highlighted it. There's nothing being transferred to anyone that's named. Now there is a signature. I don't know why that person's authorized, but there's 2 dates. And that's a squirmy thing they do so it fits into this round hole or square hole if somebody idiot like me comes along and says, hey, wait a minute, that doesn't make any sense. So Exhibit, they say in their paragraph 4, we're breaking it down by paragraph. Exhibit N attached here correctly identifies Upstart Network as the servicer, as stated in the Exhibit A. So here is and they call that their Exhibit 2. So I will show you Exhibit 2 if I can get my stuff together here. There's so many pages for you here. And that's their Exhibit N, and that's the same Sanjay Datta that signed the bill of sale earlier I showed you. And he's just saying, we're services. In case you forgot about this, we are a servicer. It says literally, certificate of chain of title by the loan servicer. A servicer is never an owner. They're either an owner or a servicer. And there's some deep policy FDCPA thing about that, but I'm not going to get into that. So just briefly, Shazam, in that Exhibit N from number 4 here, Upstart Network is not assigning anything. They don't show a present intent to transfer anything. It shows it's only a servicer, not a transferor. So then they go number 5, Shazam. Hey, look at our Exhibit A. That's the Exhibit A we're talking about in Exhibit K. This is what we're talking about. So let's look at it, Shazam. And so that shows Exhibit A, loan register investor name is Upstart Network Inc. How can they be a servicer if they are an investor? An investor is an owner. So their own documents literally contradict what the document they just presented it in. Put up N again, Shazam, and N says, we are services. And in case you're wondering why they do that, because they've stressed the importance in later documents of being services so that they can say, hey, we did this for the other guy in our role as servicer. So the Exhibit N again is, we are loan services, we're loan services. Exhibit A, loan services, right? But they do say in paragraph 2, purchasing creditor's loan register investor name. So they are claiming to own it themselves as the investor. They haven't invested in anything. And then they give us this great list where they say that Delaware Loan Purchase Trust sold it on the 28th. Well, if you recall, the bill of sale, let me put the bill of sale up again, the first one, Shazam. There's Sanjay Datta saying on the 26th, he sold something to Crown Asset. But in their own documents, later on where you force them to supplement. See, this is the beauty of a motion to dismiss. You force them to exaggerate on something that may have not been the proper thing they should have said. And they're always trying to prop up different parts of what they said. And here's where they fail. They're saying on the 28th, there were a loan trust, gave it to somebody, and then Crown Asset on the 28th owns it. So their own documents contradict their own bill of sale. So here's a question. Look at that Exhibit A with just Finwise Bank, Upstart Network, Delaware Loan, Crown Asset. There are no assignments between those parties. That's important because you have to have assignments. You can't just say, this happened. So that's, my point in telling you, they just created 4 more assignments they have to show, at least 4, maybe 3 or 4, that they didn't really plan on showing before I got involved, and now they've got a whole plate of wrong. They've made things worse for themselves. So I must implore you to look at this legally. A motion to dismiss is gonna cause problems to the other side. And I showed you my motion to dismiss video with the answer on motion to dismiss, where they just said, I'm not dealing with this. We're settling the case, because they know they don't have it. This particular firm feels like because of the amount, they feel like they have to go and say what they're saying. So then they said at number 6, Shazam, the next 2-page document produces an email originating from Upstart Network to Delaware Loan Purchase. I'm not going to read anymore. I just want to make a good point to you here. You've heard me say an assignment, a bill of sale is not an assignment. I think we're all educated enough to know an email is not an assignment. But look at this thing, Shazam, they're claiming that shows ownership. And look at the signature. Upstart Network Inc. by Dave somebody, name Dave somebody, title CEO. So it's an email. So if you recall, a valid assignment in Michigan, quickly, there it is, specifically states that assignments of things in action must be signed by the party to be charged. It's not a mere technicality, in writing and signed with the authorized signature of the person to be charged. Okay, so where's the signature? If it's an assignment, even if it's an email, it's got to be signed. There is no signature authorized or otherwise, and they know that. If you take a look also, they don't have a date. They don't have a date, and there's a reason, because now you got to really hold their feet to the fire. I've had this situation before. That's the first thing, and the court goes, yeah, where's the date? How come he hasn't signed it? So I think the court will do that here. So here's the 5 things that are wrong with that email masquerading. 7 things that are wrong. 8 things that are wrong with that email. Shazam. Number 1, it's an email, not an assignment. Where's the actual date the email was sent? The document is unsigned. The Michigan law requires a signature. It's void as a matter of law. So if you take down one of these assignments, and remember that, if you take down one of these so-called assignments or bill of sales, the whole thing collapses. It's a domino effect. So they've got to have a complete chain of title. Number 6, no present right with no date. So when did the transfer occur? No assignment, so no standing. That's what the judge said. In order to show standing, you got to show an assignment. And then number 8, where's the 2017 account purchase agreement that the whole thing is based upon? So number 7, the last document produced entitled the bill of sale. Here's that bill of sale again that I showed you at the beginning. Shazam. This contradicts their Exhibit A. If you recall, the September 26th, this was signed, and yet the Exhibit A says, and so Delaware is supposedly signing and sending something to Crown Asset up there. So it's done. They say it comes effective September 27th, but as we know in Michigan, it isn't tomorrow or yesterday. It has to be, you have to have a present right. So let's just say the 27th somehow is legal. Their own documents say Delaware sold it on the 28th. Crown got it on the 28th. So that's my point in doing motion to dismiss. It'll make them bring out documents. You have to cause legal chaos. The motion to dismiss, and don't doubt yourself. You're looking and goes, doesn't make any sense. This does not make any. You break it down. Please break it down. It becomes very clear to you when you break it down. Then you cause chaos. Just remember, under the statute of frauds, Upstart cannot sign for Delaware Trust. So a servicer can't sign. Here they're saying, we're the servicer. Well, where's the authorization for them to be the servicer? They can't. So at the end, you have this. Shazam. Finwise Bank to Delaware Trust doesn't exist. Finwise Bank to Upstart or somebody doesn't exist. Upstart Inc. to Crown Asset doesn't exist under the statute of frauds and Michigan case law. Now, I took everything they gave me, everything I'd done, all my thoughts, even this, and just kept uploading to ParkerGPT, and it did the job. And it did the job better than anybody else because ParkerGPT is just for debt defense. So don't go generalizing in other chat boxes. This is me selling this thing, I get it. But think about what I'm saying. If you wanted to get your car fixed, you wouldn't go to a brain surgeon. So I'm a mechanic, I'm a debt mechanic. If you want to go to a brain surgeon because they're smarter and have more knowledge, you're unlikely to get them to fix this thing properly. They're going to spend all day researching it and give you the incorrect information. You want your car, your debt car fixed? Come to the mechanic, ParkerGPT. Again, attached I'll have a couple of motions to dismiss, the third-party complaint I filed against the trust, and that causes legal chaos, but I was right. My show notes, and that's it. I got a lot of the show notes, but that ParkerGPT, I don't like to tell you to do something unless I do it. All my cases, all my instructions, I've done them all. I've been in every situation you've been in. And today I used ParkerGPT for about 6 hours. This is what it all produced, everything. And it can do that for you. This will get embedded into ParkerGPT, so it's available for you. You can see this video, you can see all my 1,200 forms, all the cases. We pulled all these cases, about 1 million cases, and put them into ParkerGPT because we don't want hallucinations. And there's a lot of stories about lazy attorneys signing something and then filing it with the court, and the court's going, "What are you kidding me? That case doesn't exist." We don't want that. So we're very focused on just handling debt mechanics, not brain surgery. You don't need a brain surgeon. And I'm definitely not a rocket scientist or a brain surgeon, but I am a debt mechanic for you. Let me fix your financial car. Sorry about that. Bye.